Well, Jay Sekulow is on the president's, he's the key member of the president's legal team, and Jay's joined us. Jay, is the president relieved? Is he happy? Is joy in the White House today?
There's a happy spirit in the White House last night, and including today as well. And the president, of course, is glad that this is over. And as he said from the outset, there was no collusion and no obstruction, and that is now the conclusion of this 2-year investigation. And of course, as one of the chief lawyers involved in this case, I will tell you that, Pat, I have appreciated the prayers of a lot of people that are watching this broadcast right now, and our legal team did a phenomenal job. God was gracious, and a lot of students from Regent University Law School that became lawyers in the last, say, 10 years got to work on this case. So that was pretty historic, too.
Let me ask you about the origin of all this stuff. There's a fellow named Christopher Steele, a Brit, a questionable gumshoe type, and there was that Fusion GPS dossier. How did all this thing start? Can you tell us about the origin of it?
Yeah, I can now. So there's this counterintelligence investigation that starts called Crossfire Hurricane. And that investigation is in large part based on FISA warrants and the Christopher Steele dossier, which also led to some of these FISA warrants. We now know, and as James Comey himself said, they were unverified and salacious. It was funded by Fusion GPS, and that created a very serious issue legally and politically, frankly, is what ended up happening there. The end result of all of this was the fact that you have a development that took place, and under the law, both under the law involving this collusion conspiracy theory and obstruction, the fact was there was no evidence of either. And as the Attorney General said, there was no evidence to bring forward an obstruction case. Bob Mueller called it difficult facts and law, and you don't bring cases when you've got difficult facts and difficult law.
Well, the president can fire an attorney general, and he certainly can discuss cases with his subordinates. How can that be obstruction?
Well, the Department of Justice said it can't be, and you can't have obstruction by tweet. So whatever theory may have been proposed, and I'm kind of speculating on this, as it was reviewed. So what you saw in the letter was where the line that says, well, we don't conclude the president committed a crime. We don't exonerate him either. There's 2 points on that. Well, prosecutors' jobs aren't to exonerate. They either prosecute or decline to prosecute. Here, they couldn't make a determination of whether there was a violation, so they, pursuant to basically Department of Justice policy, took it to the Office of Legal Counsel. That's the office that would look at the theory they're proposing, looking at the facts, and determine if there was a legal violation. And the OLC, in conjunction with the Deputy Attorney General Rod Rosenstein and the Attorney General, determined there was not. In fact, if you read that provision of the order, it says, in cataloging the president's actions, many of which took place in public view, the report identifies no action that, in our judgment, constitutes obstructive conduct that had a nexus to a pending contemplated proceeding and were done with corrupt intent, each of which, under department's principles of federal prosecution guiding charging decisions, would need to be proven beyond a reasonable doubt to establish an obstruction of justice case. And again, they reported no actions that would reach that level. So it was a sweeping victory all the way around on this issue, and I think this is a good day for the United States.
Jay, one thing we pointed out, it looked like it was a perjury trap, that if the president had gone on, there's almost no way that you can avoid perjury, and you and Rudy kept him from going onto that trap. How did you get it done?
Well, look, the president wanted to be fully transparent and fully cooperative, and he was. I mean, 1.4 million pages of documents were sent over to the special counsel. Dozens and dozens of witness interviews by White House officials for hundreds of hours took place. And we provided responses in writing. So I actually think what happened here was a request for an interview with the president, which they made, we did not think was appropriate under the law. In other words, the law that establishes the basis upon which you would have the right to basically interview the president, which would require, under the ESPY standard, that you couldn't get this information from any place else, that they could never meet it. And that's ultimately why I do not think they sought a subpoena.
Let me ask you about what these congressmen are doing. It's my understanding that they have to be it has to be pursuant to some legislative initiative to go through all these subpoenas and so forth. Am I correct in that, or can they just go on a fishing expedition?
You're 100% correct. So there has to be what's called a legitimate legislative purpose for them to move forward with the hearing. So you've got Judiciary and House Intel, and they've got oversight. And the question you have to ask is, what is the appropriate legislative purpose for these inquiries? And that is issue number one. And here's another thing that I think is very important for the American people to understand. This went on for 2 years with the auspices of a special counsel. And as I said, they issued 2,800 subpoenas. They executed 500 search warrants, 500. They obtained more than 230 orders for communication records, issued almost 50 orders authorizing the use of pen registers, and that's how you track phone numbers going back and forth, 13 requests to foreign governments for evidence, and interviewed approximately 500 witnesses and came to the conclusion, no obstruction, no collusion. So what is it exactly the House is doing?
Are you guys going to go after the Democrats on declaratory judgment to say that they need to shut them down, or are you going to just...
The way it works is the White House counsel is initially responsive to document requests that come in to the White House in official capacity, whether it's to witnesses or to the White House or to a department. Our job will be requests that come to either us as lawyers or come to clients or our client, the president, and we are going to respond accordingly. I will tell you that. We will respond accordingly and we will respond appropriately. But this is a little bit in the land of the absurd that after this report, you would see at this particular time, in my view, with all of that information I just gave you about the scope and nature and depth of this report, that they would allow this to continue in the House and Senate. They should be legislating, not investigating.
Are you going to get any rest now that this thing's over?
Well, you know, the week is early. Look, as you know, Pat, and I've appreciated your call. You've been calling and checking on me, and I appreciated that. Look, this has been a tremendous, for a lawyer to handle a case like this at the highest levels representing a president of the United States, there's not a higher honor. It was exhilarating. It was challenging. It was allowing me to use all the skills that I was trained to use. And I told my colleagues the other day, we were all trained for these moments. And let's remember that. That's what we were trained to do. And it was by God's grace that we saw a great conclusion. And I thank our legal team. And there will be more work to do. But hopefully it will not be at quite the intensity of, let's say, the last 2 years.
Congratulations. God bless you.
Thanks, Pat. Appreciate it.
Jay Sekulow, who is President's counsel, he and Rudy Giuliani together are the chief counsel of this entire matter. He is, of course, the chief counsel of the American Center for Law and Justice. He's been a dear friend for many years.